Okay, so far nobody has spoken up in the comments to tell me what you would really like to see as far as content goes. So I've decided to go ahead and record a few debriefs, a few issue spotting samples of crossover essays from past bar exams. They're reasonably common, and one of the most common forms is to have the last call in an essay involve issues of professional responsibility. Usually there are 2, sometimes 3, earlier calls, most often 2, that involve one of the substantive law subjects other than PR, but the hypothetical involves attorneys, and the final call asks us about professional responsibility. When you get one of these, one of the most crucial things is to leave yourself enough time to do well on that third call. Here we have call 1, asking if A, B, and C can each be held personally liable for the economic loss to A's client caused by some disclosure of confidential client information. This has to be about what kind of entity do they have, because you're not personally liable for somebody else's conduct unless you're in some sort of an agency relationship, some sort of a business association. Okay, that's call 1. Call 2 asks, may Abel, Baker, and Charlie, A, B, and C, each be held personally liable for David's malpractice. All right, call 1 and call 2 look very much the same. So we know that Abel is part of whatever this association is between Abel, Baker, and Charlie. But now we've got David. So I think the issue here is going to be, did David somehow become part of whatever this business association is, so that it would subject A, B, and C to liability for David's conduct? So far this looks like pure business associations, but then we get to call 3, and it asks if A, B, and C have breached any rules of professional conduct. This is a past California bar hypothetical, so of course the instruction is answer according to California and ABA authorities. And you know that it has to involve some area where California and the ABA differ. So call 3 is PR. Call 1 and 2 look like straight business associations. We're not being asked about the underlying tort. We're being asked about personal liability. Okay, very common kind of structure for a crossover essay. I'm going to want to leave 15 minutes in a 1-hour essay for call 3. I need to do a good job on professional responsibility, because you know that first impressions are vital, and so are final impressions. That third call is important. What have we got in the hypothetical? We see that Abel, Baker, and Charlie are successful attorneys who set up a law firm under the name ABC Legal Services, LLP. In other words, limited liability partnership. They agreed to share profits and losses equally. Abel prepared the documents required to register the firm as a limited liability partnership and instructed his assistant to file them with the Secretary of State. Inadvertently and unbeknownst to Abel, Baker, and Charlie, Abel's assistant never filed the appropriate documents. Okay, so the whole issue in calls 1 and really call 2 as well is what kind of an entity did they have, and would that subject them to joint and several personal liability? And then I suspect in call 2, is David part of that entity? So At the very least, these people have a general partnership, and maybe they have an LLP. So what do we know about the law of partnerships? Let's take a look at it. Okay, how do you form a partnership? Let's open that and see that there are formalities required. And those formalities really don't require a writing, and they don't require you to literally say we're forming a partnership. What they require is that you have contract capacity, that you have the intent to form a partnership, and that the purpose for this association is legal. Look at implied intent, and you see that it's based on conduct. No consideration is required, no writing is required. If you form a general partnership, the effect is that the partners will have joint and several unlimited personal liability. They share profits and losses. They can, in a writing, vary the percentage of that share. But what we're really interested in is what their obligation is to third parties. What is that joint and several liability? Partners have joint and several personal liability for debts, contracts, torts, and breaches of trust. So in forming a partnership, they've subjected themselves to joint and several personal liability. Okay, but do they have an LLP? Because if they have an LLP, then they've shielded themselves from that joint and several personal liability. Because what we're looking at is the law of general partnerships. So let's get this thing scrolled down and take a look at the last topic in our partnership schema, which is other statutory business entities. We open that up, and the first thing we see is LLP, Limited Liability Partnership. And what do we have? We have that all partners elect limited liability status, and we have required formalities. Well, if all partners elect limited liability status, then no personal liability for partnership debt, no tort liability for acts of co-partners. So that's what they were trying to form. But look at that. You have to have required formalities met. You have to complete the filing. And if you fail to satisfy the formalities, there's no limited liability. The entity would then be a general partnership. There's no de jure formation of one of these limited liability entities. You have to give notice to the public that you're limiting your liability. And of course, that notice is provided by the public filing with the Secretary of State. Okay, now we have the law. What did we have here? We had that they agreed to share profits and losses equally. It looks like they formed a general partnership at the very least, and I would want to go through that in my answer. I would also want to talk about all the law we just covered on limiting your liability by forming a limited liability partnership, and show that they did not do that. It doesn't matter that they didn't know that the paperwork hadn't been filed. It hadn't been filed. End of story. There is no limited liability partnership. They are fully, jointly, and severally liable for each other's acts carried out within the course and scope of the general partnership, because they're all agents of each other. Okay, so what do we have next? Abel, Baker, and Charlie leased office space for 4 attorneys in the name of ABC LLP. Doesn't matter that it says LLP, it's a general partnership. They rented the extra office to David, an attorney who had a small solo law practice, that's call 2, for a monthly rent of the greater of $1,100 or 10% of his billings. David committed malpractice arising from a case that he undertook soon after he moved into the ABC LLP office space. Okay, so now the issue is, did David become part of the partnership? If he did, they will be jointly and severally liable for his malpractice. If he did not, then there will be no liability on their part. So go back to that schema and look at what it takes to show the intent to have David be a partner. It would be implied, and the facts that we use to show intent are profit sharing as prima facie evidence, an agreement, or other conduct. We don't have that. What we have is rent, and we have profit sharing versus discharge of debt. Receiving a percentage of the profits as discharge of a debt doesn't constitute intent to form a partnership. So those juicy facts they gave us about the percentage as rent don't prove that he's a partner, and I'd want to discuss all that. And I don't see any evidence of those facts that show intent. What we have is simply the fact of the greater of $1,100 or 10% of his billing. So yeah, that paragraph is everything I need to analyze call 2 and to show that absent other facts that are not evident here, David has not become part of the partnership, and so A, B, and C are not subjected to personal liability for David's malpractice. What about paragraph 3? Abel, Baker, and Charlie hired Jack as head of computer services. Jack had just graduated from college with a degree in computer science. Jack, in an effort to save ABC LLP the cost of internet access budgeted at $500 a month, accessed and used the wireless network of an adjacent law firm for free. Abel, Baker, and Charlie were surprised at the savings, but did not inquire how it came about. Their use of the network resulted in the disclosure to a third party of confidential client information for one of Abel's clients, which caused the client economic loss. And that all goes to call 1 and also to call 3, PR. So, what are we going to do with this? Start with call 1. May A, B, and C each be held personally liable for the economic loss to Abel's client caused by the disclosure of confidential information? Yeah. Short answer, yes, because here we analyze what kind of a business entity they formed. We show that they formed a general partnership but did not successfully limit their liability by forming an LLP because they failed to file the necessary statutory paperwork. As a general partnership, that means that each of the 3 is jointly and severally personally liable for the torts of the other partners committed within the course and scope of the partnership. And I would want to note here for the greater that although they're jointly and severally personally liable, that a third-party creditor cannot collect from them personally until the partnership funds have been depleted. In other words, the partnership is primarily liable. The partners are secondarily, personally, jointly, and severally liable. So in call 1, I'm not going to talk about professional responsibility because that call is not asking me that. All it's asking me is whether they have somehow made themselves personally liable for the economic harm caused by one of the partners. I'm not going to fight the fact that there was economic harm the hypothetical tells me there was. So that entire call is an analysis of the form of the business entity and what that means. As to call 2, we've talked about that quite a bit. It goes back to the form of the entity as well. And whether in a general partnership, David had become one of the partners. Given the facts in the hypothetical, he had not. But if David's client can establish other facts that show intent, then they could be personally liable for his conduct, just not from what we're given here. All right, the PR call. Have A, B, and C breached any rules of professional conduct? Well, they have not by renting an office to another attorney. We do that all the time. Those of us who are not in large law firms. All right, what about hiring Jack and what happened after that? That's what was necessary to answer call 3. And so I'm not going to go into great detail about PR, but let's talk about some of the issues you could raise here. You could raise the fact that they failed to supervise Jack when they should have, because he was a brand new graduate. They're responsible for their agents, their employees' conduct. Responsibility is multiplied, not divided. They knew that they were getting internet for a bargain price, if not for free, and they failed to inquire. They just celebrated the fact that they weren't having to spend money on it. That isn't what you're required to do as an attorney. You're required to supervise, and you're required to inquire when something's going on. Okay, so all those issues of supervising employees come up. Issues of the requirement to maintain confidentiality, and we've talked when I did PR debriefs, issue spots, about the difference between ABA and California as far as confidentiality. So I won't go back and hammer that, but California is much more stringent. What else could you raise here? Well, a big one for me that I don't see often in the answers that come back on this one is that this was a crime. Jack committed a crime. He stole internet service from whoever that service provider is. So A, B, and C are assisting in the perpetration of a crime by hiring him, failing to supervise him, and failing to ask questions about why they were getting free internet service. And I really would want to hammer that in my answer. Assisting in a crime is misconduct. That's a really serious offense. I think you can probably come up with a lot more issues under professional responsibility. And I encourage you to do that. But remember to give that third call the full weight it deserves. I hope in this debrief, as well as in the others that I've done, that I've at least convinced you that what you're tested on in a bar exam is a limited set of law. It's not anywhere near as detailed or in-depth as you had to learn in law school. And the analysis you do on a bar essay is certainly not at the level that a law professor would expect on a law exam. Bar essays are entirely doable. And as always, if this has been of use to you, the best thing you can do for me is twofold. Share this so that other people start watching these videos, And also, comment and tell me what other kinds of content you would really like to see that would help you out.